Yes, I mean, like I've said earlier, when there are some latent contradictions in the evidence of the contradictions has to be material contradictions. If there are no material contradictions, then basically the law allows you to reserve some of your reasonings and allow the matter to go the full.
Let me highlight one of the reasons that the judges said. At that time, they also said that to them, the prosecution relied on the EFCC to the extent that it was basically about intelligence gathering and not necessarily some of the prosecutory or evidence that they had. And to that extent, some of them also thought, look, or how would you classify that, material or immaterial?
Yeah, well, for me in person, I'm talking about my opinion now. That's the way the judges, I mean the chairman and the member of that panel saw it. If I were to be in their shoes, I would see it differently. I am not in their shoes, but then for me, I have a right to give an opinion on this, and my position really is, it will not matter whether the evidence is coming from proper custody or not.
Even if they were oral evidence.
Yeah, because it wouldn't matter if the person, you see, it's like I was expecting A to come and talk about a particular thing, and you see, the law remains the law. It's easier for the Code of Conduct Tribunal to say, because EFCC was involved, we decline jurisdiction. It's a different ball game. That look, we don't have this. I believe they do. But then, if the CCT now feels that we don't have the right to look into matters that in which EFCC operatives will give evidence and all whatnot, it would have been better to decline jurisdiction and say, look, let it be transferred to some other, rather than saying that because it was made by another agency of the government, therefore we don't see any.
That was just one.
Yeah, it's just one of it. Yeah, yes. I brought up one, which is the bond document, and this is another one. So I felt really that if it goes on appeal, there is the tendency that some of the charges may fail, some of the charges may be brought back.
What about the credibility of the whole process? When you say that a prima facie case has been established, even if, as we also have a testifier saying that they actually transferred this money,
right?
Is that enough to run with for the prosecution?
Well, it's enough for me, because you see, we're talking about. Let's bring up an issue. Let's assume that we're talking about stealing, and somebody said it was taken, and somebody said it was transported. It was taken away from where it's supposed to be to another place. Yes, whether we like it or not, the iota, the necessary ingredient has been brought to the fore. At that point in time, it is not the sufficiency now. At that point in time, it is not whether the man will be able to survive what he has said that really matter, but the fact that he has made somebody say, yes, I was the one who did it, and I did it for you. For a good number of us, we felt a prima facie case is already made. Not necessarily that if at that point in time, not that he has won, not that it has been proved beyond reasonable doubt. Proving beyond reasonable doubt is you have called the other side and you have evaluated, you weigh the
so they didn't even have the documents to prove beyond or prove.
No, it's not about documents.
They didn't get to that stage.
They have not got to that stage. No, the man said the document got burnt.
That's oral evidence.
Yes, and the truth is, if the document got burnt, can there be other? Can you rely on what he has said? Yes, the court may say, well, we don't want to rely on it, but you cannot say you don't want to rely on it at that stage, at that point on time. Because basically, the man has alleged, the man has said so, I did it for you. It's like a man who said, I helped you to ferry your money, I helped you to courier your money from a particular place to another, and you say, yeah, where is the evidence that you did it? But the man, you need to confront him. The essence of no case submission is for a man for the judge to look at it, whether it is worthy of calling the defense to come and answer a few questions. Even if you are not answering all the questions, if a man has made this kind of very huge...
But the prosecution will be seen as not doing its own due diligence completely when it's relying on hearsay.
No, that's not hearsay. Yeah, in fact, let me agree with the truth that, look, hearsay evidence is unacceptable. That's the truth. To succeed for anybody, even be it civil or criminal matter. And the chairman of the tribunal and the other member made that, they said categorically that the evidence of a particular person was hearsay. And how did it become hearsay? Because they said it was the work of a team. Witness. No, they said it was the evidence he led was the
information from his team.
Information from his team. For me, I don't really think that should be the correct understanding of the law, because we work as a team. It doesn't matter. It could be CCB team and about 3, 4, 5 of us. We know it. Police, they don't work. I mean, they work together. They work in team. They work in teams, right? You could get like 3, 4, 5 persons together to investigate a particular matter, and only one person goes to court to say this is the way we saw it. But then fear for fear, that's the way the tribunal are saying it. But I'm hoping that somebody else will do. I mean, that's the beauty of the rule of law. That's not the end of it.
Do you believe it's going beyond this?
Yeah, they should. I mean, if if they see it from the angle from which I am saying it, because basically, if a man has come out of a 5-man team to give an evidence over a particular issue, and we are now saying that, look, it's an hearsay. For me, it is not.
But we also had a similar case where there was a no-case submission, that of Justice Ademola. And then many will also think that this whole anti-corruption fight, and where you have no case submissions after all the hoopla, you'd have thought that they have ironclad cases to the extent that there will be no such thing as a no submission case.
Well, no case submission has come to stay in our legal lexicon. There's really, it's not only in ours, it's part of the law, and whether we like it or not, it comes up in smaller cases too, in cases that are not involving the big men in the society, and so basically it's part of the law, and the processes are quite, I mean, the proceeding is quite simple. I mean, somebody has alleged, and the judge, the other side, has every right to come up with a no case submission application, and if it's upheld, definitely it amounts to an acquitter. But then that does not mean that the other side cannot go upstairs appealing against it, and if it does, well...
Are you saying that the no-case submission is hurting the judicial processes in our country?
Is what?
It's hurting the judicial processes in our country.
Well, the no-case submission is not strange. It's part of the judicial system. It's part of the judicial system.
So why are you opposed to it?
No, I'm not opposed to it. I didn't say so. I'm not opposed to it. I'm just saying that it's part of the system, and what I'm saying is that in this...
We'll come back and look at this. Yeah. Just give us a moment. Don't go away.